So as you've probably just heard, the briefing is being recorded. So if you don't want either your image or your voice to be on the video, then it's your choice. It's up to you. I will share my screen. This is where you see the technical issues I always get into when I do these things. And if someone could just let me know if you can see the slides.
Yeah.
Yeah, it's fine.
Yep. Just going to go into show in a second. Perfect. Just still a few people just coming in. So we're going to cover a few things this morning. Probably over time, anyone who's involved in HR or managing people has a cause for concern in relation to employees' behaviour or attitudes or conduct outside of the workplace. And as much as we've got a degree of control over what happens within the workplace, it's difficult sometimes to deal with what happens outside of the workplace, certainly when such things don't happen on what I would say is official events, so company-sponsored events. So in this session, I'll just introduce myself. This is just, I've put a picture of a nice breakfast there, just in case anyone actually wonders what a nice breakfast looks like. Although there's beans on it, and I don't know if that qualifies for a Scottish breakfast. I'll leave that debate for another day. So over the course of today, we're going to cover kind of three main things within the next half hour or so. We're going to look at employees who hold what I would say is controversial opinions, really. So things which are maybe contrary to kind of general public opinion. Over the past year, the kind of rise of the, let's say, the anti-vax movement, which has gone from beyond people holding personal views about vaccinations, which is kind of relatively common, to people suggesting that the vaccination programme is much more sinister than that. So we'll talk about people who hold controversials inside and outside the workplace. And I've got some examples, and certainly some experiences that I've had in my own working life where I've had to deal with that. The second thing we'll talk about is conduct and criminality, really, that happens outside of the workplace. So probably anyone who's kicked about in HR for long enough has had to deal with things that happen, let's say, on official events. And quite often their defence for these things was about whether an event was official or it wasn't. So whether it was company sponsored or company facilitated or on company property or funded tended to be a kind of deciding factor in what we as employers would do about it. But that's kind of subtly changed and continues kind of subtly change over the period of some time. And the last thing we're going to talk about is social media. As someone who is not really on social media at all, we're going to talk about what social media can do, some of the issues that it relates to, and what our responsibilities are, and what we can do about things that happen on social media away from the workplace. So over the course of the past few years, I think people tend to suggest that free expression tends to be getting more and more restricted, and lots of people are talking about things like cancel culture, where people are not given platforms to view opinions which are contrary to, let's say, what might be public opinion or what is perceived to be public opinion. The fact of the matter is that the right to express yourself and the rights to freedom of speech have been espoused, for 3 generations, and certainly currently under the Human Rights Act 2010, we all have the rights to hold pretty much whatever opinion we like, and to espouse those views within certain parameters. With rights tends to come responsibilities, and the right to freedom of expression does not really confer anyone the right to talk about any views under the guise of that freedom without any form of responsibility. There's obviously restrictions on what we can say, prescribed by law, in the interest of things like public safety, public decency, national security, and for prevention of disorder, or where those views are contrary to other elements of legislation, such as preventing discrimination. That's a kind of long way to say that employers are free to hold views, and within the restrictions and responsibilities from just slightly before, those views may well be contrary to widely held views or what are deemed to be acceptable to the general population, or indeed to our company values. So determine whether the rights of an individual are those rights between the individual and the employer is a really delicate balancing act. And all of these things, and we kind of always say it, for most things that people contact us about, there is a reasonableness test to these things. It's not the job of an employer, and nor is it our right, to make a determination on what people should believe, or even how they profess those feelings, or what opinions that they hold. The adage is we can't really change the way that people think. We can try an organisation to look at culture and educate people on things like this, but we can't force or impose a change on people. What we can do as an employer generally is impose standards of conduct. So we can change what people do, but we can't necessarily change the way that people think. So in my previous life, I had a member of staff. I don't know if you remember, a few years ago, there was a WikiLeaks about membership of the British National Party, and one of my employees was on it. It caused a degree of disquiet in the workplace. It was also a member of the EDL, the English Defence League. When I spoke to him, he was quite open about it, and I think all of his colleagues were understood it, and it was what it was. So EDL is if no one knows, far-right Islamophobic organisation who their principal tenet is they reject the concept that anyone who professes or follows the Islam or is Muslim can be regarded as English or British. So as an organisation, it's legal. They're not a political organisation, they're essentially a pressure group. And I would say, and I don't want to give away my own personal feelings, but to most right-thinking people, have an employee who's an avowed member of such an organisation is difficult, and is probably contrary to what we profess to be our company values. There's effectively no provisions in law to dismiss or discipline somebody for their views, and there's unlikely to be anything in our codes of conduct or our handbooks that gives us the automatic right to dismiss someone for holding views, even if those views, as I say, are very contrary. Crucially, and I think we'll come back to this point routinely over the course of this morning, it's the responsibility of an employer to demonstrate that holding such, or very importantly, the reaction to the knowledge or the widespread knowledge of those views is so bad that dismissal is a potential or indeed only outcome. So things that could affect that might be the reaction of staff, the reduction in credibility of the individual. So as an example, if an individual was, let's say, a salesperson or had a kind of ambassadorial role within the organisation, and this became widely known, certainly through the media or other means, then it may become difficult. Or any other factors that kind of mean that continuing employability is no longer compatible. So can employers still be taken seriously, or is it damaging relationships if they voice these opinions? Like everything where dismissal is potentially an option, we would need to initiate an investigation, find evidence of what happened or what we aim to rely on in terms of a dismissal. But crucially, that would be the impact of the behaviour or the conduct on the workplace.
Ryan, needed for the summit.
Sorry, we've got a voice coming through. That's fine. In the words of my recently retired colleague, if no one knows, Andrew Munro, the esteemed Andrew Munro left us last week. Andrew's principal tenet was contextus est omnis. He's a lawyer, so they tend to go into Latin when they don't think I can understand it, and which is context is everything. It may well be easier to argue that dismissal is the only option if the employer's business is diametrically opposed to the views held, and the organisation is essentially a value-led organisation. For example, you might have read recently an English nurse who was dismissed, I think last week, or certainly went through an appeals process last week, and that she was anti-vaccination, so suggested that COVID vaccine was useless, that the virus in itself was synthetic, that the principal design of that synthetic was to bankrupt the general population of the UK, and that the NHS was complicit, and finally that Donald Trump would lead a new world order to reclaim the presidency and the right thinking from the left wing. Patently, those kind of views made her absolutely incompatible with NHS work, being that a principal part of her conspiracy theory related to the NHS. On the other hand, there are assuredly COVID deniers who exist in our workplaces today, whether that's anti-vaccine or something much more sinister. So while it is straightforward to make a case for a nurse who espouses that the NHS are complicit in this wide-scale corruption, it can be more difficult if someone's a fitter in a workshop somewhere. Generally, we need to think about, and as I said before, we need to establish what the impact on the employer and employee relationship is, and whether that, it spreads fear or alarm in the workplace. Now for the kind of bah humbug section. This is not a member of Scottish Engineering staff on a night out, incidentally. This is just a general Google image. The conduct of our employees at nights out can be actionable at work, and that's whether it's our official Christmas lunch or whether it's a group of employees who just decide off their own back to go out for a beer after work. We've had a number of examples this year of when behaviour outside of work has led to issues within work, and again, from both official functions and unofficial functions. And that's, the extent of that has been things like unwanted physical conduct, suggestive statements, assault, or a raft of other issues that have happened between workmates, but away from the office. So as before, and as I will keep coming back to, the impact of these actions can and does have a detrimental effect on workplace relationships, and sometimes between the employer and the employee. We need to be ready to deal with it. So we don't really need to think about whether a night out is official or not in relation to whether we need to deal with it. But what we do need to think about is what is the impact this has had in work, and what will this do to workplace relationships? And is that so serious that it warrants a disciplinary penalty, or at the more serious end, a potential dismissal? So again, initiate an investigation and determine not what we think might be the reaction, but what actually is the reaction. If you've got one person who's done something outside of work and 9 workmates say, I can't work with this person again because of what they have done, then we need to think about what that means for the ongoing employment of that individual. So we'll get back to this a bit more towards the end. Christmas night's out patently as party season for most people. So another thing which, again, we take routine calls on is people who've broken the law outside of the workplace. And this is a tricky area, except for some regulated industries. So some of us might be in regulated industries, let's say people who work with defence industry or people who work in social care. There's no blanket requirement for an employee to inform their employer of any police contact. And that's all the way from getting stopped in your car right the way through to custodial sentences. There's no general requirement for you to tell anyone that that has happened. I used to work for the Scottish Prison Service, and there was a contractual responsibility to inform the employer. And I used to work in the defence industry, and once again, there was, but that was imposed by effectively a regulator rather than the employer. It's important to remember that a conviction for pretty much anything is not in and of itself automatically a reason for dismissal in general. That's regardless of whether it's an assault in a pub or something much more serious or much more sinister. And I think it's also important to think about separation from our own feelings of moral outrage about what someone has done, or even our organisation's feeling of outrage. We need to think about the requirement to demonstrate to a reasonable third party that a dismissal was warranted, and that the reason for that was public outcry or customer complaints or demonstrable reputational damage. And we'll talk about that a bit more in a second. So again, we've had things like assaults in and outside of the workplace, sometimes at the factory gates, criminal damage and charges of possession of illegal images. None of these in and of themselves warrant automatic dismission, and any decision that we take needs to be tied to a detriment to the organisation, whether that's the feelings of colleagues or employees, the feelings of our customers, or general social media or media outrage. A decision to dismiss is unlikely to be justified unless you can demonstrate that the act has an impact in the workplace, but not just that you think it might. So if someone gets done for some kind of offence and it makes the front page of the paper, that doesn't automatically mean that you can demonstrate you've suffered reputational damage. You would need to demonstrate what that reputational damage is. So if we think about the nurse earlier on, and this is not tested at tribunal yet, I suggest that if you were to do so, an employer would state that, in addition to what allegations she made, the views were taken were so diametrically opposed to the values of the organisation. Now, whilst organisationally we might have values, we might have a value set, a mission statement, whatever that is, it doesn't necessarily mean that that's a central tenet of our organisation. Most organisations on this call are commercial organisations. So whilst we may have values, it's not necessarily what we trade on. It might be part of what our good name is, if you like. Arguments like that might hold sway in a value-led organisation, one which trades on values or ethos, but not necessarily for all of us. So to be a fair reason for dismissal, we would need to show that the misconduct outside the workplace, the criminal conduct, justified the dismissal of the employee holding the role. Sometimes that can be things like if it's fraud or embezzlement or financial issues away from the workplace and the person who committed it is our financial controller, then you might stand a chance of being able to make that case. We need to also show, as we do in any dismissal, that the decision to dismiss was reasonable in all of the circumstances, including size and admin resources of the employer. And it would need to show that the response to dismiss was in the range of reasonable responses, which is basically the reasonableness test related to any dismissal. The tribunal would examine whether you'd carried out a fair process, for example, looking at what the factors surrounding the conduct, and whether you'd carried out a fair investigation. Again, any dismissal needs to follow a fair investigation, except in very, very narrow circumstances, and whether you considered any other dismissals short of, any other sanctions, sorry, short of a dismissal, and followed the ACAS code. In general terms, if someone doesn't break our codes of conduct or any of the rules that exist in the organisation, but their continued employability is no longer compatible, which is a nice way of saying we just don't want them here. The fair reason for dismissal is called some other substantial reason, which is a kind of catch-all. Fair reason for dismissal. It is a fair reason. And what basically that said is that continuing employability is incompatible, but not because of broken a rule or committed gross misconduct in the workplace. It's potentially fair. The test for SOSR, it used to be a catch-all for organisations to just think, well, I can't really think of a good reason to dismiss you, but I'm just going to dismiss you. So any SOSR dismissal, some other substantial reason, is generally keenly tested by tribunals because we need to demonstrate that it was the action kind of last resort. So just like anything from an ACAS investigation, from the ACAS Code of Practice and any other investigation, we need to investigate the facts in the same way we was doing an investigation, determine what happened and determine whether we felt it was a case to answer. So importantly, like all of these things, if we are going to rely on reputational damage, we might need to gather evidence from customers who'd stopped using us or from people who had complained to us or anything of that nature. If we were relying on workplace outrage, then we would need to gather evidence statements or witness statements about that outrage. We can't just say that it might happen or we think it's happening. We need to evidence it. One of the things which we might need to think about is suspension. Suspension has erred between, in my time in HR, which is lengthy, between being regarded as punishment and then we say that it's not punishment, it's not a punitive measure. Suspension is fair when it allows us to, or it's the only way that allows us to conduct a fair investigation, or where there is a potential for ongoing harm to the employer. So if someone is, let's say, committing significant health and safety breaches and we're not assured that they can work safely, or in this case, if someone has been charged about a criminal offence which we believe might cause issues in the workplace, then certainly suspension is something we can consider. One of the things I used to work in, I used to work in the prison service. So a great way to start a conversation is when I was in the jail. If you don't explain yourself very quickly thereafter. But where police are involved, as quite often happens, where there's public assaults, or has happened with one of our cases recently, an assault at the factory gates. The police should not really form part of any part of the investigation, nor should be present at or get notes of meetings or disciplinary meetings, because that could prejudice a criminal case. If the police seek to get that documentation, then they would need to do so via court order, and that's generally pretty unlikely, but regarded as a matter for the employer. And again, back to that SOSR dismissal, it's always one that I would suggest, if you do take our services, that if you're considering that as a concept, please seek advice on that kind of individually and separately. But in terms of the question that we're going to be asking, and I don't intend to read all these out to you, we need to make the link between the employee's employment and their conduct. That might be role specific. We might treat senior management differently from people on the shop floor by nature of what they do and the role that they have. So if they have a leadership role, then that might have an impact on what we do. And then we need to think about what impact has this had on the person's ability to do their job, or the people who come in contact with them, their reputation with them. Is it going to impact on sales if it's a business development person? In terms of disciplinary action, we need to think about the full range of responses. So if this is someone who got in a fight outside the pub and won, we need to think about whether it's proportionate to dismiss that person or impose some kind of different disciplinary sanction. And certainly, I know we've got people on the call from regulated industries, so social care. What are our responsibilities to report this to someone else, to our regulator? And if we report that criminal act to our regulator, does that mean that the regulator will disbar them from our work? And then we need to work out what that means for us. So that's pretty much would form the kind of tenets of the case that we would seek to make in order to demonstrate that a disciplinary penalty in general or potentially dismissal was an issue. And just to kind of round off this morning, I'm going to talk about social media. I wouldn't say I'm a massive opponent of social media, but social media is becoming, I think, a more difficult environment. It gives everyone who wants it a platform to kind of expose or promote their views on anyone who cares to listen. It's become very difficult to avoid social media. So even if you're not on Facebook, if you're not on Twitter, if you pick up a newspaper, 50% of newspaper articles will be about, social media storms about one thing or other. In theory, from a social media perspective, there is the potential to ring fence your own output such that you can speak to the group who you choose to speak to, but it generally doesn't work like that. The concept of posting something and it going viral is huge, and certainly unless you're pretty smart with your privacy settings, that's what can happen. So there's a thing about social media in that if you say something verbally to a couple of friends in a pub about I hate my job and my employer is this or that, then you need to consider whether such a thing, even if you heard it, was actionable. And the fact is, it's probably unlikely to be actionable. But if you go online and say that my employer is corrupt or is doing something which is unlawful or which is calls into question their governance or their compliance, then patently that's something we can have a think about. We often determine that because people have said something that's derogatory, then it follows that it's damaged their reputation. But as I've said before, we need to be able to demonstrate how that reputation has been damaged. And as I say, unless you're an organisation whose kind of principal tenet, principal source of your reputation is your value set, it can be pretty difficult to demonstrate that. You know, all of us have probably take issue with some of Amazon's working practice, or Sports Direct's an example, and yet both companies kind of thrive despite the fact that potentially from a value set, we don't necessarily agree with them. So the capacity for your opinions being voiced publicly, and more publicly even than you thought, is enormous because of social media. There's an annual outcry, and I don't know whether anyone's aware of this, but if anyone's on Facebook, people like and share posts, and there's an outcry every year and a surprise every year that people share posts about Remembrance Day, Remembrance Sunday. I think there was an article in The Guardian last year, and it was repeated again this year, that they reckon around 80% of the kind of images and messages of support about Remembrance Day generally 80% come from far-right organisations. So the English Defence League, Britain First, the British Nation Party, all these kind of people, a lot of them tend to promote issues like this, and by liking it, it kind of creates an inextricable link between you and ultimately that page. We're also, we'll have people in our workplace who are, anti-vaccine, COVID conspiracies. Such content like that is also generally derived from kind of far-right groups who, whilst you may agree with COVID's conspiracies, or you may agree with that, you don't necessarily agree with everything that they say. Well, holding these views, as I've said before, even if if it's not unlawful, it's not automatically a reason for a conduct warning or a dismissal. So if someone on Facebook posts something that you don't particularly like, then you can switch it off. But again, I'm always going to come back to what impact does this have in the workplace? Has this caused outrage? Has this caused an issue between employees? It's a further thing about bullying online. For me, the jury's out on whether organisations should have a social media policy or shouldn't. I think it's so tricky to nail down what every element of social media. And if you see a lot of, I see a lot of company handbooks who talk about things like MySpace and all of these kind of things, which are no longer in vogue. And I say this as a man kicking 50. So it can be quite difficult to actually nail down what's right and what's wrong and what you're going to do about it. In most cases, things like bullying and harassment, if that happens online, as quite often is the case, then I think generally you can rely on your own bullying and harassment policies to deal with that. You don't generally need a separate social media policy. You might like to issue guidelines to staff about what they should be doing in social media, and certainly things where they are inextricably linked with the company. So things like LinkedIn, where you will trade on the fact that you work for your employer and you're inextricably linked. And we've probably seen, if anyone is a routine user of LinkedIn, you've probably seen some examples of that where people have espoused views, and then there's the inevitable kind of social media pile-on. So that's something for us to think about, is whether we have a social media policy. If anyone takes the services, we do have template social media policies if it's something you want to think about. But I would suggest it's one of the things which we talk about routinely with staff about what, posting something on social media, the impact that this can have on our colleagues. So just to round off, I know some people have joined us late. There was some time confusion, but don't need to worry. The session is recorded. For me, organisationally, an organisation should have a code of conduct. I think whether that's in your handbook, whether that forms part of your disciplinary policy, but it should be greater than just the things that if you do wrong, you'll be disciplined. I think it should talk about what you are as an organisation, what your value set is, and the types of behaviour that you expect from your employees and those core values. And that should be supported by senior management team and made pretty accessible. And it should be something we talk with routinely about our staff. What's expected in work, what's expected outside of work when you represent the company, and be pretty clear on what the potential impacts of breaching that code of conduct is. Social media, I think whether that's a policy or whether that's guidelines, it should also be something that we talk to our staff about. It's, you have your own free expression to post whatever views you like on Facebook, but I think sometimes we need to make sure that staff understand the potential impact of that on colleagues. So that's something which people don't necessarily think about, sometimes don't really care about, but where it becomes something that we think we need to action, then it's something we need to think about that. I think it's good to spell out your guidelines in case, you seek to make a case about it and someone can probably with some justification say, well, you never told me what was right or wrong. So that's one of the things to think about. And kind of lastly on this, it's one of the things we need to do is update our disciplinary policies and make sure that we cover all the bases in relation to potential out of work conduct, including online. Remember that while it's important to apply your rules consistency, you will need to assess each case on its own merits. So there can't be any blanket judgment about if you say this, then this, if X, then Y. It doesn't really work like that. Such like, defence is your best offence. So be proactive and kind of unambiguous in your use of policies and contracts and handbooks to set out how you are as an organisation. It might seem obvious to say that certain behaviours are unacceptable, but certainly it's unlikely that anyone would have had COVID conspiracy theories or anything of that nature in any of their handbooks a year and a half ago or 2 years ago. So whilst we take each case in their merits, it's important to be even-handed in our dealings. A tribunal will fully consider the matter from yours and the employee's perspective. So for employers, it's easy to fall into the trap of, as an example, overestimating reputational damage that might follow from an employee's conduct. And that's quite often what we deal with, is that employers will contact us about this, and generally they will overestimate the impact or even suggest that an impact has happened when it hasn't, but they fear that it might. So to underline all of that, and in everything pretty much that we relate to, any dismissal at any stage and for pretty much anything, we need to demonstrate that it's within the range of reasonable responses, the proportionality test that a tribunal would impose on what we do. So is this the only thing you to do? Was this an action of last resort? So a couple of minutes early, just a couple of things we've got on the go. We've got our legal update, as you'll see the dates there. We also have an inclusive engineering webinar tomorrow morning at 8:30, which is a free event. We're going to look at capability dismissal, and I think our next breakfast briefing, which we hope to be early in January next year, and our first line management training, which has gone down a storm. We have availability in March 2022. If you're interested in any of the events, you can contact Sarah, who will have sent out your invite for today, and Sarah will discuss what that means. But the legal update will happen fairly soon, will happen next week. I've got in 2022, I was ahead of myself there. So I have finished for this morning, pretty much bang on time. I'm a professional. Does anyone have any questions about anything we've talked about this morning? I don't know whether silence is technical issues or silences. I don't have any questions. You've covered matters perfectly. Nothing at all anyone wants to talk about?
Can I just ask one question?
Sure.
If an employee posted on a social media platform like Twitter or, well, especially Twitter or Facebook,
Yep.
and then actually named the employer,
Yep.
what would you recommend the employer would do on that respect?
I would have a word with someone about their actions, and I would say that this is linking us to your views, which we don't want to do. We don't want to be associated with your views.
Bad mouthing the employer.
Well, as I think we're saying earlier on, you would need to demonstrate that what they had said was so serious that it's damaged the employer-employee relationship. I mean, I think there'll be employers on here who will understand that there'll have employees who will go out and talk to the pubs about their pals and say that I hate my work and, you know, it's a terrible place to work. And there's not really a great deal that you can do with that. People are, you know, it's free to be their own views. But essentially you would need to demonstrate that it damaged your relationship so much that the dismissal or a disciplinary penalty of some regard was justifiable.
It's just that also a colleague of mine,
Yep.
there in their organisation, one of the employees also tweeted, and obviously it was to, I think their customer in America actually seen it and reported it back to them.
Yeah, and that's the kind of thing where
Reputation.
you'd be able to demonstrate the reputational damage, that a customer had seen something and that they had, you know, this is the impact that it had. So whether the person, you know, the organisation reported it and said, you know, we don't think this is acceptable, we're taking their business away, or had just let us know, by the way, someone's posted something, you might want to have a look at it, might be determination of what you do with it. If someone took business away, then it's likely to be, and that was the root cause, you're likely to consider disciplinary penalties at the more serious end. If someone's just informed you, oh, by the way, I've seen this on LinkedIn or Twitter, you might want to do this, you might want to have a chat with them.
Well,
then
my advice was just to have a chat with them and let them know that you have been made aware of it.
Yeah, and I think that is what I would do, to be frank, unless I could demonstrate, if that customer in America took their business away and I could demonstrate a detriment to the organisation, then I would think about it. As I say, unless you were a really value-led organisation, and again, everything would need to be taken on its own merits. If it was something that was, I don't know, racist or discriminatory and was severely so, then you might need to think about what does that mean for the organisation if we're a value-led organisation. But in general terms, if we haven't reminded people about the impact of social media, I would use it as an opportunity to remind people about the impact of social media.
Okay. Thank you.
No worries. Anything else?
Nope.
So I know some people have joined us late. I think there's some time confusion. The meeting is recorded, or the webinar is recorded, and it's just really been me talking for half an hour, so nothing really exciting has happened. So I will send it out to you and you're free to watch it later on this evening. You can connect your phone to your TV and let the family share it. I don't mind. But if there's nothing else, thanks for joining us this morning. If you're interested in any of the events on screen, I will send the recording out within some point this morning once converted. And I'd like to wish you all a very happy, peaceful and safe Christmas and hope to see you, all of you in 2022.
Thank you very much. Same to you.
Cheers.
Thank you very much.
Bye.
Thank you.
Cheers, Dermot. Bye.